So thank you, Caroline. So what I wanted to talk about, and you will have seen if you've had a quick look through the abstracts, is something quite experience-based. I haven't done a lot of kind of pedagogical reading in preparation for this. It's much more about what I've been doing this semester and how well it's gone in trying to do something in a new way. And I should say as well at the outset, I'm very interested to hear what the other speakers on this panel have to say, because I'm hoping we'll all have slightly different things to say and slightly different approaches. So hopefully it'll be a really good learning experience in that way as well. So I've just taught a new course for the first time that I wrote over the summer and have been teaching and just finished teaching. The final assessment deadline was in fact yesterday. And the course is called Global Legal Histories, and it's intentionally a plural. And it's designed to look at legal history from a different perspective from the traditional doctrinal approaches, which would focus usually on one legal system. And indeed, that's the way I was taught. So I'm going to outline how the course looks and talk about some of the deliberate pedagogical choices that I made and a little bit about how it went in teaching it for the first time. So the first thing I want to talk about is what the purpose of this course was. So Edinburgh offers really quite a large range of different legal history courses, more than most UK universities, maybe more than any other UK university. And students can choose to study a more sort of traditional Scottish legal historical topic, as well as, or instead of this course. They have quite a lot of flexibility. So it's an optional course for students in their third or fourth years. It's also open to students on other degrees, so international relations, for instance. And it's open to students who are in Edinburgh on year abroad programmes, what was Erasmus and won't be Erasmus anymore, Canada, the US. So it's a real mix of students. And that mix poses its own kind of pedagogical challenges, because making any assumptions about existing legal doctrinal knowledge is really problematic. And I think I had about a dozen different jurisdictions represented in my seminar class, which had 32 students. And that included a number of students who actually weren't studying law and hadn't ever formally studied law before. I also didn't have access to any particular student texts or textbooks to give them, because as far as I'm aware, those don't exist. There is a collection of essays called Global Legal History, edited by Joshua Tate, Jose Ronaldo de Lima Lopez and Andre Botero Bonal, but that's broadly speaking designed for an academic audience and not students. So I had to make decisions kind of from scratch about what the course was going to use for material. And you'll see in a moment, the course structure does sort of vaguely resemble the outline of that book anyway, because it seemed as good a place to start as any. I didn't feel that we could study the topic particularly profitably through the lens of case law, for instance, because that would have required a lot of time getting everybody on the same page, and potentially have not been very interesting as well. So the other thing as well, and this is something that Russell's picked up on in his book, Subversive Legal History, is that if we're studying it doctrinally, there's some sort of implicit sense, and Feluke was also talking about this as well, that there's particular concepts of law, legal ideas that you're bringing with you to the study, or even just particular rules from particular legal systems. And that really wasn't what I was going for here. So I think quite unusually, we ended up with a legal history course, which actually doesn't have primary sources in the form of case law, statute, or legislation. We do talk about those things, but we're not using them as our sources. And of course, students are free to explore those as further reading. They're bringing pre-existing knowledge, some of them, but it wasn't the main reading list. And you do lose something in doing that. The discussions were grounded in particular examples, particular times and places, and I'll come back to that in a moment, but not particular pieces of law. And I think that may have had some knock-on effect in terms of the written assessments, in terms of the students not necessarily being confident about the material they were using to illustrate their points in their written essays. And I think if I was teaching this, say, exclusively to third-year law students, as you might be more likely to do in an English university rather than a Scottish one, I probably would have thrown in some case law and statute to use as examples in discussion. And in fact, I may do that next year and shake things up and see how it goes. I also didn't want, the other thing that was really important to me was I didn't want to dive into studying different places around the globe without a clear methodological structure, because that seemed likely to produce quite bad work intellectually speaking. And I've seen quite a lot of that in my own research, where I do a lot of work with Victorian legal history and Victorian historians. So I didn't want to be sort of replicating those mistakes. But as global legal history is still an emerging field, and the literature so far has actually been dominated by a fairly small selection of voices. Thomas Duva is probably one of the most notable figures in the area in terms of writing and producing literature. So I've included his work in the reading list in several places. And comparative law, comparative legal history, again, they're their own fields. So I'm trying to not actually to generate consensus, but to gather material from lots of different places, acknowledging that there's a lack of consensus about how we go about doing comparison in legal history methodologically. And I thought it was very important to teach the students not just kind of here, this is how we do it as if it was settled, but to actually expose them to those controversies and invite them to explore and evaluate for themselves. So this on this slide is just an outline of what the course structure ended up looking like. So you can see it was split roughly into 3 sections, teaching students some different methods for approaching comparative legal history, making it global, picking up on some different jurisdictions from around the world, and then revisiting some classical comparative law topics and seeing what they made of them with this new global lens in mind. Now, obviously, I could have started with the stuff that's at the end, the more conventional topics, and that may well have been easier for some students, particularly those who already had some experience studying common law or studying civil law. In Scotland, it's likely that they've studied a mix of both. But I deliberately didn't want to do that because it seemed to me likely to encourage that kind of inflexible thinking that we've already heard a little bit about this morning, or thinking that sticks to traditional lines, rather than opening up some of the more interesting conversations which I really wanted to be having. So we began by thinking about why you might want to explore law and history together, what the pitfalls might be, what some different views on the subject are. I included on the reading list, for instance, a piece by Robert Gordon on why lawyers might find history uncomfortable or threatening to their premises, to try and get the law students in particular thinking about that right from the very outset. What about my legal training so far has encouraged me to think like a lawyer, thinking in a certain way? What about that might be critically challenged by thinking about history or thinking historically? So immediately introducing this idea of critical legal history, or what Russell calls subversive legal history, which is obviously slightly different, and he's going to talk about that later, so I won't go into that. And putting that alongside the possibility of historical study challenging ideas inherited from the past, and particularly the colonial past. Again, we've already heard some of that this morning. So we explored a number of different ways that people have engaged with comparative law and legal history in terms of method. We looked at the German historical school, and this set us up very nicely to think later about common law, civil law, codification, topics like that. We talked about the ideas about legal culture, legal families, Alan Watson's transplants, Patrick Glenn's idea of legal tradition, and exploring these concepts alongside each other as different possible approaches to the same questions. I hope, encouraged students to engage with the fact that global legal history is quite a new idea, and to think about how that field can and should develop and kind of have a stake in it themselves. From my perspective, I encourage them to think about these methods as tools on offer, not exclusive, but well designed in each case for some purposes and not others. And in the field of comparative law, Jacques Husser has been talking about this in his work as well. And the students did tend to have their own views on the merits of different approaches. So figures like Savigny and Maine, who are very well known in sort of the history of law, the intellectual history of law, they were considered very small-minded, and it was actually quite hard to get the students to consider the value of their contributions, notwithstanding their limitations. Alan Watson was popular up to a point. Patrick Glenn was considered too vague. And giving the students the space to engage with these theories and tools on their own before we kind of got into the case studies, I think enabled them to develop a more mature and sophisticated approach before we got into the sort of substantive doing legal history. And I think that really came across in the written work this semester. You'll notice as well in the case studies, there's some emphasis on colonial or post-colonial law, which is partly student-led because many students are quite interested in discussing these topics. And it's also an interesting way to frame legal history global legal history for some fairly obvious reasons. And again, opening up those wider questions. We're not just asking how legal systems relate in a sort of a technical way, but thinking about the wider economic and power structures, thinking about how those influence both history and law, and that obviously seemed very important. And it also ties in with my own research interests, which are broadly speaking in historical jurisprudence, so it's nice to teach your own research. So the jurisdictions were selected based a little bit, they were a little bit arbitrarily selected, I will admit. India I already knew quite a lot about, so I knew that I could teach that well and sort of comfortably for me as a teacher. Japan was chosen because it is quite a distinct and unusual legal system and provides a nice contrast to cultures where law was kind of imposed by colonial powers, because Japan was quite self-selective in what law it adopted from foreign cultures. And Spanish South America, because it's quite a rapidly growing body of literature. There's some really interesting ideas about the role of custom in Spanish South America and colonialism. And again, I'm personally interested in that, so it seemed like a good place to go. Obviously, in teaching a course that is this wide-ranging, and indeed teaching it on my own, there are limits to my own knowledge and to the time that I have for teaching preparation. So something I'm considering for the future is using guest seminars, guest lecturers with people who are actually experts in other jurisdictions, which I hope will open up a wider range of topics. So if anybody wants to volunteer a jurisdiction for next year, please let me know. Reading wise, the students had about 4 to 6 items a week, usually included a chapter or two from the Oxford Handbooks of Legal History or Comparative Law, using that to fulfill that kind of textbook function that I didn't really have. They had articles or other book chapters from the jurisdictions under discussion, because we all agreed right at the outset of the course in the first seminar that it was really important, if you're studying a place, to listen to the voices of people from that place. Ironically, then when we then did it, there was some difficulty, because particularly German writers were found to be very, very difficult to understand, even when writing in English. There were discussion questions built into the reading list to try and guide the reading each week and point them towards questions that we hopefully would be able to discuss more fully in seminars. So it was quite a structured course, and deliberately so. And again, partly responding to the fact there was a big variety of students. So just very quickly before I stop, evaluation reflection. Again, we've only done this course once so far, but my thoughts so far. The sector generally, I think it's fair to say, has an attendance problem for seminars at the moment. I don't think that has anything to do with the course, but it did make it a little bit difficult to get discussion going, to get that kind of dynamic discourse flowing when lots of students were absent all the time due to the acute and long versions of COVID, due to economic constraints and whatever else it was that was stopping them. So attendance was a bit patchy, and I don't think that's anything to do with the course in particular. There was something of a reluctance to actually engage in verbal discussion, even using the technique of small groups. And I think that comes back to the fact that the students were from a very wide variety of places and backgrounds academically. That they were actually very good at using the methodological tools that we developed in the first part of the course in their case studies, and actually did pretty good comparative legal history. The first essay assignment was quite ambitiously on my part an assessment of the usefulness of Friedrich Karl von Savigny's concept of Volksgeist as a methodological tool in legal history. So not a simple or basic question. And some of them wrote really, really good essays, and generally speaking, they all had a really good go at it. But when we were actually studying the methodological tools, the students found it quite difficult to understand what they were trying to get out of it. They didn't have a case or a piece of legislation they were seeking to understand. So we had to do some extra work on kind of skills, reading skills, note-taking skills, which I wouldn't have normally done, I think, in a legal history course. But just because I'm aware of time, just to sort of round off, one thing I would say went really well with the course was that by the time we got to the end, the students were actually bringing up their home jurisdictions that they were more familiar with. They were bringing that in as a comparison. They had the confidence to do that. So I think the main thing that I've learned in terms of how I would go about teaching this course in future, and perhaps is generalizable for teaching global legal history to a global audience of students, is that I think this sort of methodology grounding followed by case study approach works quite well. But I think it is very, very important early on to build confidence in their ability to engage with the material. And I'm still figuring out how to do that. And again, it is a different approach because we're so used to, particularly in law schools, basically letting the material speak for itself using the kind of thinking like a lawyer legal method. And when you consciously kind of reject that and try and do something else, then obviously you're kind of out in open water. But as I say, I think it's been a really interesting experience. It has actually gone really well, and I'm really excited to continue to develop the course in future.